So, put together the preamble and the directive principles comprise the ideology of egalitarianism, and that is the rulers of independent India committed themselves to bring about political, economic, and social equality and bring to an end the age old sufferings of the people. The state, that is, governments at the center and in the states, were required to follow these principles in the determination of their policies and executive actions. So, in connection to that, after the formation of Indian Republic on 26 January 1950, the first Union Finance Minister Dr. John Mathai announced that the government had decided to set up the Planning Commission, and that Planning Commission that so that the development of the country could be taken off in planned manner. So, in consequence to that, the 5-year plan was launched by the government after India became a republic. So, in that connection, also some other developmental projects that we could discuss. The National Farming Cooperative Farming Advisory Board prepared several plans and promoted the program of cooperative farming. Most of the states set up such boards. The Dandakaranya Development Authority organized cooperative farming for the benefit of displaced persons. So also the Union government on 2nd October 1952 launched the Community Development Program, and also in the subsequent year, in 1953, the Union government launched National Extension Service, and in January 1958, the National Development Council recommended that in order to bring about the development of rural areas, there should be a devolution of power and decentralization of machinery for the exercise of such power, and that such a machinery should be controlled and directed by popular representatives of the local area. So, in pursuance of this recommendation, Panchayat Raj system was established with a three-tier structure of local sub-governing bodies at the village, block, and district levels. Specific powers and functions were assigned to these institutions in the field of development and local administration. Almost the entire country was covered by Panchayat Raj, and which were further strengthened under the 73rd Amendment Act of 1992 by the Union Parliament and the Land Reform Committee of the Parliament and Planning Commission as such provided for land reform in the entire country. So, the legislatures of almost all the states and union territories passed Land Reforms Acts which fixed ceilings on land holdings and the surplus land acquired from landowners was distributed among the landless workers. So, this Land Reforms Act of various states compelled by the legislature for equal and proportionate distribution of agricultural land holding in India. And in that connection, we could have to refer the Bhudan movement of the then Congress leader Acharya Vinoba Bhave, and on whose appeal and influence many landlords in the country they donated their surplus land into the Bhudan Trust, and in consequence it would be possible to ameliorate and remove and eradicate inequality in the holdings and distribution of agricultural lands in India. And in 1969, a number of measures were taken towards to achieve the very goal of egalitarianism. And in that connection, we could make the reference that in 1969, 14 top commercial banks of the country were nationalized, and in this same way, in 1980, 6 more private banks were nationalized by the central government. And besides that, in the same year, in 1969, privy purses to the ex-rulers of the princely states and the special privileges of the princes of the ex-royal families of India were abolished. So, also after abolition of privy purses and the special privileges to the princes or the ex-rulers of the princely state, we could visualize the establishment of an egalitarian society or egalitarianism or egalitarian social order in India. And besides that, also there are certain labor legislations which were brought, and some of the existing labor legislations were amended by the Union Parliament to remove inequality, exploitation of the labor or workers, and in that connection we could cite the enactment of Employees State Insurance Act, Minimum Wage Act, Workmen's Compensation Act, Besides several amendments to the Industrial Dispute Act of 1947, the Factories Act of 1948, so also the Trade Union Act of 1926. And now we'll go to another important aspect relating to that is as to the very socialist patterns of society. So, regarding that, the Indian National Congress at its 1955 Avadi session adopted a resolution on economic policy. It stressed what became known as socialist pattern of society. The Abadi resolution on economic policy and the very adoption of socialist pattern of society was reiterated at the Bhubaneswar Indian National Congress session in January 1964, and finally it was adopted, and in 1976 the then late Prime Minister Mrs. Indira Gandhi, under the 42nd Constitutional Amendment Act of 1976, included the very word socialist or socialism into the preamble, and which is now is considered as one of the basic structure or basic framework of the Constitution, as it was declared in the most important leading case, Keswananda Bharati versus State of Kerala in 1973. And now we'll go to Article 41 and what exactly Article 41 deals, and that in connection we'll discuss some leading cases. So relating to Article 41, as it provides right to what? To education and to public assistance in certain cases. So, the very direction to state is that the state shall, within the limits of its economic capacity and development, make effective provisions for securing the right to work, to education, and to public assistance in cases of unemployment, old age, sickness, and disablement, and in other cases of undeserved want. So, in that connection, we would like to discuss some important leading cases, such as the first one, Sambhavana versus University of Delhi. In 2013, the Supreme Court pronounced that a duty on the state to make effective provisions for securing inter alia the rights of the disabled and those suffering from other infirmities within the limits of economic capacity and development has been imposed on the state under Article 41 of the Constitution of India, as it was decided by the Apex Court in 2013 in this important leading case, Sambhavana versus University of Delhi, and the second important leading case relating to Article 41 and in particular to right to education is the All India Institute of Medical Science Students Union versus All India Institute of Medical Science in 2001, Supreme Court pronounced that reservation other than constitutional reservation is subversion of fraternity, unity, integrity, and dignity of individual. Extending reservation beyond undergraduate medical education is keeping the crippled forever. So it was an important pronouncement as relating to reservation in postgraduate courses of medical education. So now we'll go to another important relating case. Exclusive dealing Article 41 is Dental Council of India versus Subrati KKV Charitable Trust, and it was decided in 2001 by the Supreme Court, where it was pronounced that the jurisdiction of court to interfere with the discretion exercised by experts body like Medical Council of India or Dental Council of India is limited, even though right to education is concomitant to the fundamental rights, as it was pronounced by the apex court in this important leading case, Dental Council of India versus Subrati KKB Charitable Trust in 2001. So, in this video, we have completed up to Article 41, and in our next upcoming video, we will discuss the very provisions of Article 41 and how far its very ambit was expanded on the very interpretation of the Supreme Court. So, in that connection, we would like to discuss two important leading cases also. So, in our upcoming video, we will discuss Article 42, 43, 43A, also Article 44 and